What is VTL 1192? 2. DWI Per Se Me08+. A single chemical test result can be enough to charge you with DWI in New York, even if you showed no visible signs of intoxication whatsoever. New York Vehicle and Traffic Law Section 1192, 2 is the state's DWI per se law, and it applies the moment a blood alcohol content test shows a BAC of 0.08% or higher. The Latin phrase per se means by itself. And under this statute, the BAC result alone is the offense. No swerving, no slurred speech, no failed field sobriety test required. This sets VTL 1192, 2, apart from common law DWI under VTL 1192, 3, which requires prosecutors to prove intoxication through officer observations and behavioral evidence gathered at the scene. New York also recognizes DWAI under VTL 1192, 1, for BAC levels above 0.05 but below 0.08, and aggravated DWI under VTL 1192, 2A, when a driver's BAC reaches 0.18% or higher. Chemical testing in New York can involve breath, blood, urine, or saliva. Though roadside portable breath tests are typically screening tools for probable cause, rather than the primary evidentiary result, the reliability of any chemical test depends on proper administration, equipment calibration, and strict chain-of-custody procedures that must be followed from the moment of testing. Under New York's implied consent law, operating a motor vehicle in the state means you have already agreed to chemical testing when the statutory conditions for a stop and arrest are met. Refusing the chemical test triggers a separate DMV administrative proceeding where a first refusal can result in at least a 1-year license revocation and a $500 civil penalty. That refusal can also be introduced as evidence against you at trial, meaning it removes one piece of evidence while simultaneously creating another that prosecutors can use. A first VTL 1192-2 conviction is typically a misdemeanor carrying up to 1 year in jail, fines between $500 and $1,000, and a minimum 6-month license revocation. A second offense within 10 years escalates to a Class E felony with up to 4 years in prison, fines reaching $5,000, and a minimum 1-year license revocation. A third offense within 10 years rises to a Class 500 felony, exposing the driver to up to 7 years in prison and fines as high as $10,000. Beyond criminal penalties, a conviction can trigger mandatory surcharges, a driver responsibility assessment, ignition interlock requirements, and serious long-term insurance consequences that follow you for years. Attorney Randall F. Inniss, who holds an instructor-level designation in standardized field sobriety tests, represents clients charged under VTL 1192-2 throughout Rockland County and across the Hudson Valley. The law firm reviews every aspect of your case, including the traffic stop, testing procedures, custody timing, and available defenses, and provides a comprehensive 16-page document outlining your options. When you are facing a charge that can reshape your future, having a knowledgeable lawyer carefully scrutinize the prosecution's evidence can make a meaningful difference in the outcome. Call the Inniss firm, PLLC, at 845-533-0265, located at 400 Rella Boulevard #165, Suffern, New York 10901, to discuss your case and your next steps today.